Okay, let's be real for a second. Nobody enjoys a dispute, right? I mean, whether it's a business deal that's gone south or just a simple contract disagreement, the path you're usually told to take leads straight to a courtroom. And we all know what that means. It's expensive, it takes forever, and it's just plain stressful. But what if there was a better way? It kind of makes sense that a country famous for prioritizing gross national happiness would be the one to figure this out. So let's dive into how this small Himalayan kingdom created a really smart blueprint for solving problems more peacefully.
So where does this whole system come from? Well, it's all laid out officially in one comprehensive law. The document we're digging into today is the Alternative Dispute Resolution Act, which was passed back in 2013 by the Parliament of Bhutan. And I think this is a really important point. This isn't some informal, centuries-old tradition. Nope, it's a modern, carefully built legal framework specifically designed to give people a real, solid alternative to going to court.
So, just put yourself in this situation for a minute. You're in a conflict. Do you really want to deal with months, maybe even years, of all the formal legal battles? What if you could find a way to solve it that was faster, way more private, and maybe didn't completely destroy your relationships in the process? That's the exact problem, the core issue that this whole act is trying to fix.
And Bhutan's answer to that big question? Well, it's this very act. It's all about creating a formal, government-backed alternative, a system that puts finding an agreement or a fair decision way ahead of those long, drawn-out court fights. All right, so here's our game plan for this explainer. First, we'll look at why this system was even created. Then we'll meet the main organization that runs the whole show. After that, we'll explore the two different paths you can take to solve your problem. And finally, and this is the really crucial part, we'll see how they make sure the final decision actually sticks.
First up, a new path to justice. So why go to all the trouble of creating a whole new system? Well, it really fits perfectly with Bhutan's big idea of gross national happiness. I mean, think about it. The law itself says right at the beginning that there's a need for impartial and independent ways to solve problems outside of court. The whole point was to build a system that helps people find their own solutions, efficiently and fairly. It's about promoting harmony and well-being, not just chalking up a win in a courtroom.
Okay, next section, the ADR Center, your guide. At the absolute heart of this whole system is a brand new institution, the Bhutan Alternative Dispute Resolution Center. The Act sets this up to be a totally independent body. It even has its own legal personality, which is a fancy way of saying it can act like a person or a company in the eyes of the law. This makes it the real engine, the central hub for this entire new path to justice.
And you know what's pretty amazing is just how much the center actually does. It's not just some office where you file paperwork. No way. It runs the proceedings. It helps people negotiate settlements. And, this is a big one, it actually steps in to appoint the neutral decision maker if the two sides can't agree on one. Plus, it handles all the training, certification, and expertise. It's basically a one-stop shop, a complete support system for anyone using it.
And to make sure the center stays stable and truly independent, the law gets super specific about its leadership. For instance, the head honcho, the chief administrator, gets a fixed 5-year term. Now that might sound like a small detail, but it's a really important one. It shows this whole system was built to be consistent and trustworthy for the long run.
All right, let's get into the nitty-gritty. How does this actually work? Well, the Act gives you two main paths. We're going to start with the first one, arbitration. Now, you can think of this as the more formal option, and the key thing to remember here is that it ends with a decision that is legally binding on absolutely everyone involved. The main player in any arbitration is something called the arbitral tribunal. The easiest way to think about it is like a private judge, or maybe a small panel of them. They're a neutral third party. Their job is to listen to both sides of the story, and then they make a final decision. And in the official language of the Act, that final, binding decision is called an award.
But this is important. You can't use this system for just any kind of disagreement. The law is super clear about what's off limits. Things like criminal cases, divorce, child custody issues, and tax disputes, those are all out. They have to go through the regular court system. So the main takeaway here is that this process is really built for civil and business-related disagreements.
And here's a great example of how focused this system is on being fair. What happens if you think the arbitrator, the private judge, is biased? Well, there's a whole formal process for that. You can file a written challenge, the tribunal itself rules on it, and get this, if you're still not happy with that decision, you can appeal it to the high court. It's a system with some serious checks and balances built right in.
Okay, on to the second path, which is totally different. It's much more collaborative. This is the negotiated settlement. You might know it by another name, mediation. And the goal here is completely different. It's not about having someone else make a decision for you. It's about getting help to reach a decision together.
So in this process, the neutral person isn't a judge at all. They're more like a facilitator, a guide. Their only job is to help the two sides find their own solution, one they can both agree on voluntarily. All the power, 100% of it, stays with the people who are actually in the dispute.
Now, this whole path is built on one single critical idea, and it's written right into the law. Section 167 says, "The parties shall participate in good faith with the intention to settle the dispute." That's it right there. Both sides have to show up genuinely wanting to find a solution. If that commitment isn't there, the whole thing just falls apart.
This really lays out the difference perfectly, doesn't it? On one side, you have arbitration, which is basically a private court. A neutral person acts like a judge and imposes a binding decision. On the other side, you have a negotiated settlement. That's more like a guided conversation, where a neutral person helps the parties find their own voluntary agreement. It really boils down to this. One is about a decision being made for you, and the other is about reaching an agreement with you.
All right, last big section, making the decision stick. So let's say you've gone through one of these paths and you have a resolution. Now what? This might be the most critical piece of the whole puzzle, making sure that the outcome actually has teeth and is legally enforceable.
And here it is, the absolute game changer that gives this process its power. An arbitration award isn't just some friendly suggestion. The law makes it crystal clear. It has the exact same legal weight, the same binding force as a judgment from an actual court. That's what gives this entire system its bite.
But with great power comes great responsibility, right? There are safeguards. A court can step in and throw out an award, but, and this is key, it can't do it just because someone doesn't like the result. The reasons are all about the fairness of the process. For example, was one side not allowed to present their case? Was the arbitrator appointed improperly? It's all about making sure the journey to the decision was just, not about second-guessing the destination.
So, to quickly recap what we've covered, Bhutan saw a need for a different way to handle disputes, one that lined up with its core values. It built the ADR Center to be the guide. It gave people two clear choices, the decisive route of arbitration or the collaborative route of negotiation. And, most importantly, it backed up the results with the full power of the law.
And all of this leaves us with one last pretty big question to think about. We've just walked through a system built on efficiency, fairness, and, mutual respect. So could this model, designed for a small Himalayan kingdom, actually offer some lessons for how we handle disagreements in our own communities or even our own countries, wherever we are in the world?